We are joined by attorney Andrew Lieb. Andrew Lieb, I believe, is a constitutional law expert. Mr. Lieb, Bud Mishkin here at 1010 Wins. Thank you for joining us. First of all, your reaction to today's ruling.
It's been quite the last 2 days between the guns decision yesterday and this overturning in Roe and Casey today. I'm going to say my biggest reaction is if you put them both together. And what we're learning is how we're going to be reading the Constitution moving forward. What we're seeing is that history and tradition takes precedence over everything else when interpreting the law. This is like a Scalia decision saying, hey, we need to look back to history and tradition. Alito wrote that we now know how to interpret the Constitution. We're going to see this be played out in the electorate. As Alito suggests, the people's representatives should be making this choice moving forward.
We heard during the Supreme Court, not deliberations, but during the congressional, when we had a Supreme Court nominee in front of Congress talking about the possibility of joining the Supreme Court, and many questions about precedent, obviously with Roe v. Wade in mind. What does today's ruling mean in terms of precedent?
You actually just hit what I think is the most important thing. And Judge Kavanaugh, who voted with Alito on this decision, made a very big point to say that Casey is precedent on precedent. What precedent means is a prior decision needs to be honored. We use the word stare decisis. And Kavanaugh said this isn't just precedent, this precedent on precedent. You referenced Casey upholding Roe in 1992. And the real risk moving forward, I think, for all citizens to be concerned about is other rights that were founded on this same right to privacy. The right to marry persons of a different race, to marry while in prison, contraceptives, a conservative one, to make decisions about your children's own education. They're founded on the same rules. And what we learn in this case is what we thought was precedent or stare decisis doesn't have the same weight. As the Supreme Court just said, when it's wrongfully decided, they use Plessy v. Ferguson as an example, it's our duty to overturn ourselves. So we can't rest assured that the Supreme Court decided, and that's the way it is. It's always subject to change.
For abortion rights advocates and abortion rights legal advocates, this is obviously a terrible day. Where do you think they go from here from a legal standpoint in terms of the Supreme Court, not state by state, but in terms of legally and in the Supreme Court? Is there a path ahead?
It's interesting you say that because there's a case out of Florida already making some headway, that South Florida that might have some grounds. You see, this court said you can't win on due process. That was the right that we found in the 14th Amendment. They said, well, you previously said you can't win on equal protection clause. But a Florida Jewish congregation is saying in Judaism, the health of the mother needs to take precedence. I'm making it simple. But they're saying, hey, isn't that a religious argument? Isn't that a situation where, you know what, you're not giving us our free exercise of religion rights, and that's religious discrimination? Maybe that's going to take wind moving forward.
Andrew Lieb is a constitutional law expert. Mr. Lieb, we appreciate you joining us here on 1010 Wins.
Thanks so much for having me.
Wins News Time is 11:22, a little bit late, but let's check in with traffic.